Welcome back to week 6. We are going to be going over chapter 5 this week and essentially talking about the victims in the criminal justice system and how they interact with each other. So, as always, I will strongly encourage you to take notes. I will timestamp this as I always do, just so that you can kind of go back freely if you miss something or need some more information on anything. All right. I will say this may be some review for some of you that have had other CJ classes before. Um, so if it's review, that's great. If not, then that's great also. We'll be learning all at the same time. So, all right, let's get started. All right, so as we get started, I want to pose this question. What is justice? Now, you may have had this conversation in previous criminal justice classes, but this is a very philosophical notion of justice. The concept of justice is one of the key features to our society, but can you define exactly what justice looks like? Well, we really need to figure out justice and what it means in order to truly understand the victim's view of the system. Justice is a tenet of our criminal justice system, and a lot of scholars have debated as to what is this notion of justice and what is the philosophy of justice. A common definition is one that your textbook lays out, and it essentially says that justice is the concept of moral rightness based on ethics, rationality, law, natural law, fairness, and equality. Now, may have heard of different types of justice, and some of these may be familiar, some of these may not be. But essentially, in order to define justice, practitioners and scholars in criminology and criminal justice have come to understand that justice can take many forms. And at the heart of how we treat each other in the system lies this foundation of how we view justice. So there are four major types of justice that your book goes over. Um, the first is retributive justice. And retributive justice is one that you should be familiar with, but essentially it is based on the principle that the guilt of an accused must be proven, and once that is established, the offender's punishment must be proportional to the crime committed. Retributive justice is all about punishing bad actors, and it's very focused on incarceration and things like that. So then we have this notion of utilitarian justice, and utilitarian justice is rooted in the moral theory of utilitarianism. And essentially, this is a principle of justice based on the greatest good for the greatest number. Um, you can kind of read the definition there. Then we have distributive justice, and distributive justice is concerned with the fair allocation of resources among diverse members of a community. A number of important questions surrounding justice have been fiercely debated over the course of Western history, like what is justice, how does it interact with society's norms of um, treatment of others, and are we truly allocating appropriate types of justice? Then finally, we have this notion of restorative justice. And essentially, justice refers to the informal and non adjudicative forms of dispute resolution, um, and it has a number of elements to it. But essentially, it is um, the focused attention on the needs of the victim and offender. Victims are active participants in restorative justice, and generally elements of restorative justice involve not only the victim and offender coming together to work out a resolution, but it also brings in the community to kind of help restore the victim and the community back to pre-crime um, situation. Really going to focus on restorative justice and retributive justice for the remainder of this presentation because those are the two main kind of viewpoints of justice. And one is especially prominent when we focus on victims, and that is restorative justice. Restorative justice, in essence, repairs the harm done to the victim and the community in an effort to change the offender's behavior. Essentially, it assures offenders' actions won't be repeated, and it seeks to use interventions that return victim and offender to pre-offense states. So you can see the four areas that kind of this notion of justice seeks to restore. And you'll notice that it's like harmony in society and social supports. So, really, restorative justice is taking the victim and offender, recognizing some of those criminological theories that state why offenders uh, do bad things and offend. So whether it be because they don't have a job and they need money, so they're robbing people, or they never really got an education, so they don't qualify to get into college or get a job or anything like that. So, restorative justice really seeks to understand the why behind the offensive behavior, but it also seeks to understand the victim's point of view and bring them together. A lot of this is done through various means that we'll talk about now. So, how is restorative justice in action? Like, how does this work? Well, it seeks to negotiate agreeable solutions and help implement those solutions. It's all about relationships, how relationships are harmed by crime, and how they can be rebuilt to promote recovery and healing. And so we really, when we talk about restorative justice, we typically think of something called mediation, and that brings two parties together to kind of work out issues and come to solution. That can happen with restorative justice, but essentially it seeks non-confrontational settings, bringing everyone together, including community members and supports for both sides. And at the heart, it seeks to understand the actions leading to the offense and kind of bring accountability back to the offender. So, restorative justice is really kind of seeking to restore everything to pre offense behavior. So, how are restorative justice and retributive justice different? Remember, retributive justice is all about retribution. And so you'll see here that the primary difference between restorative and retributive is the role of the victim in the system. And so with retributive justice, remember how we view crime as a issue against the state, not necessarily against an individual, but against the state. And the victim is simply a witness to that crime. And the focus of this system under retributive justice is really punishment and deterring future criminal behavior. Think of these as two ends of a spectrum that a pendulum swings on. And so then on the other side, you have this notion of restorative justice. And really, crime is viewed as an action against the victim and the community as a whole. And so it really kind of marries the best of both worlds and seeks to restore both the community and the victim back to pre offense behavior. And the focus is on repairing harm. It can be as simple as an apology, restitution. Um, it can be like probation and supervision and things like that. But essentially, it's about services and getting people what they need. Maybe that offender was using drugs, and so it really kind of focuses on the offender getting treatment and things like that. So now that we really kind of understand what justice is based off of which lens we look at justice through, the retributive or the restorative, let's actually talk about the justice system as a whole. So there are two aspects of the justice system. There's the criminal system, and then there's the civil system. And the victims play a role in both systems, but the victims' roles in those systems are very different. And so the criminal system is our adversarial system. It's the one that you typically think of when you think of criminal justice. It's designed to judge the guilt or innocence of accused offenders and punish or rehabilitate them. So the criminal system is really set up under a retributive model. There's been more of a push for restorative justice to enter into the criminal system. But the criminal system, there's a criminal code. That's where prosecutors tend to come in, and some of our serious offenses happen. But then you also have this other system known as the civil system. And the civil system is designed to ensure the rights of individual citizens um, are kind of restored. Uh, and one of the biggest things between the criminal and civil system that we'll get to is the civil system really is about monetary damages. And so the civil system really, you get relief through monetary damage. Whereas the criminal system is all about kind of like incarceration or alternatives to incarceration. So let's go into more detail, and let's start with the criminal code. The criminal system is set up based off of the criminal law. And criminal law is concerned with actions that are dangerous or harmful to society as a whole, in which prosecution is pursued by the state. It defines what constitutes a crime and prescribes punishment. So, our criminal law essentially sets up what is the law and what happens if you break that law. So, punishment. But one thing that you have to understand is the criminal law is governed by this notion of federalism. And that's essentially the power that is shared between the national and state government. And so we have different levels of court system that uphold the criminal law, and we have criminal law at the state level, and we also have criminal law at the federal level. Um, so let's look at the levels of the court system. And like I said, this might be review for some people, but some people it might not be. So if it's review for you, great. If not, great. But essentially, at it in the state level, we have what are known as district court levels. We also call those like superior courts. These here major civil or criminal cases. They include superior, circuit, or district titles. A lot of times you're going to hear them referred to as superior court. It's not really until you get into the federal district courts that you really kind of hear them referred to as district courts. But I mean, some cities have circuit courts like um, those that handle speeding tickets and like misdemeanor uh, offenses and things like that. With the district courts, the appellate courts are the highest level of appeal. So, with the district courts at the state level, you typically have your like superior court, which hears the case and adjudicates and kind of sentences. And then from there, you have an appellate court, a state level appellate court, that will hear appeals from that lower court. And then each state has their own state Supreme Court, which is the highest appellate court in the land, in the state land. So the state Supreme Court hears all of those appeals from the lower courts. If there's a federal constitutional issue, then state Supreme Court decisions can be appealed to the U.S. Supreme Court. But that's really if there's like federal constitutional issues is really normally your state Supreme Court is your final highest level of appeal rights that you have. So then in the federal system, you should know that it kind of mirrors that. In the federal system, they typically have jurisdiction over all cases that violate federal statutes, and they can provide judicial review for lower state and federal court decisions. But essentially, at the base level of the federal system, you have the circuit district court, then you have a court of appeals, and then you have the U.S. Supreme Court, which is the highest appellate court in the land. And they once it's at the Supreme Court, that's the highest that it will go. So that it's important for us to understand kind of the dynamics of the U.S. court system so that we can understand the victim's perspective throughout that system. So, how do people enter the criminal justice system? Well, this is a fantastic diagram. And it really kind of is very detailed. I would say, if you have any questions about like what happens at each hearing, things like that, what happens with misdemeanors, things like that, use this as your guide. It's a great summary. I'm not going to spend too much time on it. We're kind of going to go through this step by step, so you'll get some more information as we go on. All right, so let's start looking at the system through the victim's lens and kind of see how they interact with each step of the system. Now that we have kind of an understanding of what justice means, the two lenses that we look at justice through, and have an understanding of how our court systems are set up, we can kind of start walking through this system in the victim's eyes. So the first step in entering the system is actually reporting a crime. Um, if a crime isn't reported, then the system doesn't know to start being triggered and acting. So the victim essentially is victimized and then calls to report that crime. Um, when that happens, law enforcement typically will respond and start focusing on what happened, who was involved, where it happened, when it happened, all that gathering of information. Uh, Law enforcement also has some other things they focus on when they respond. They look at the victim's relationship with the perpetrator and the background between the victim and perpetrator, if there is one. They also look at quality and consistency of information, and they look at the characteristics of the victim. Now, we've talked about victim blaming and kind of how some of our victimology theories have been attributed to victim blaming. We kind of see that again here. It's kind of ingrained in the system. Uh, Law enforcement is trained to kind of start questioning the validity of the victim at the very beginning. And that's just their information gathering. So we then go to pressing charges. And essentially, Once information is gathered, um, law enforcement will determine if they have something to charge someone with. So it's important to remember that a criminal act is against the state, and the victim is considered a witness of the state. And so we've talked a little bit about how the system treats the victim, and I brought this up before, but um, when law enforcement charges an offender, they're charging an offender with a violation against the state. Even if it is a personal crime, it is um, it is against the state, not an individual. Um, if law enforcement determines that a crime has been committed, then they have to try to narrow down who the suspect is. And so they rely on the victim to kind of tell them that information and kind of help them find the offender. All in all, though, the decision of whether to press charges or not is really the police making that decision. Now, they will work with the victim, but essentially there are mandatory arrest policies for certain offenses, and discretion plays a whole lot into arrest decisions. But essentially, the decision to arrest someone and press charges is ultimately up to law enforcement. So once law enforcement presses charges, it will kind of, your book doesn't really go into this, but it essentially law enforcement meets with the district attorney's office. Together, they decide to press charges. They arrest the offender. Then we go into our pretrial stage. At the pretrial stage is really where the offender kind of pleads to the case. Whether they stay in jail is decided, and then your grand jury stage is in the pre-trial stage. So once an offender is arrested, they are able to see a judge, and that judge decides at this preliminary hearing. That judge decides whether probable cause um, has been met to keep the offender in jail pending the trial, or how much it would take for the offender to get out on bond. While all of this is going on, the district attorney also has the grand jury. And depending on the type of crime, the grand jury may have already met and kind of handed down an indictment. Um, or if it's like law enforcement arrest, the person gets out, awaiting like the district attorney to file the charges, the district attorney may um, go ahead and take the case to a grand jury. And essentially, a grand jury hears evidence against the accused and determine if there's enough evidence to go to trial. So the victim really doesn't have a role in pretrial activities. Again, they may be called as a witness to the grand jury or something like that, but you don't really like they're not really sitting in the courtroom or having a say and things like that during pretrial activities. So our next step is really the trial, and this is kind of what you think of when you think of trials. Has a judge. Most of the time, it has a jury. There are some cases where you can have a bench trial, which means no jury and the judge is the finder of fact. But this is where the prosecutor and defense attorney gets up, questions witnesses, um, and kind of all of that. Essentially, if it's a jury trial, remember juries are made up of individuals from the community, um, who sit in judgment of the defendant. Essentially, they hear all of the the facts at the trial and they determine guilt or innocence. During this time and during the trial, the victim does have rights. So you'll remember last week we talked about the Victim's Bill of Rights. And the Victim's Bill of Rights lays out the rights that the victim has during trial. So you'll see that first and foremost, the victim has the right to be protected from the accused and a right to reasonable, accurate, and timely notice of any court hearings. The victim also has a right to hear testimony in the trial and to be present at trial. Now, there may be something called a separation of witnesses order. And essentially, what that does is that makes the witnesses have to sit outside of the hearing until the time that they actually testify so that they don't hear the other witnesses' testimony so that they can't be contaminated. If that is the case, then the victim would not be in the courtroom until they've testified. And then once they've testified, they're able to kind of sit in the courtroom. That's only if one of those orders are in place. Most of the time, the victim would sit in the courtroom. They would have their victim advocate there, kind of walking them through. They would be talking to the district attorney, things like that. But this Victim's Bill of Rights, which you have a copy of, kind of outlines all of the rights that the victims have during these proceedings. And you'll notice that um, victims have a lot of rights that we would have taken for granted. But remember, it wasn't until 2004 that we actually had them written down. So, if the offender is found guilty, the trial moves into what's known as the sentencing phase. Sentencing hearings may be held at which evidence of aggravating or mitigating circumstances are considered. So the judge takes into consideration maybe some outside influences as far as mitigating factors go. Aggravating factors would be like things that would increase sentencing. Like if it was a hate crime or something like that, that could be considered aggravating factors. Or if they had like a weapon in the commission of a robbery or something like that, that could be aggravating factors to increase sentencing. But at the sentencing phase, the victim really kind of gets to shine. And they get to shine because they get to present something called a victim impact statement. Now, I touched on victim impact statements last week, um, kind of went into some of the history of victim impact statements. We know that they really kind of originated in the 70s, but were not widely utilized until the 90s. It is important to note that some victims choose not to to present victim impact statements. Some victims are scared to face the accuser. Um, there's also um, just some issues with cooperation. They may not be scared, they may just not want to cooperate, but they have the right to give an impact statement. Sentencing is normally the final stage, and this is where your restitution can be ordered and included in that sentencing order. Um, and we talked about restitution. It's essentially trying to pay back monetary damages. Um, but let's talk a little bit more about victim impact statements. So, victim impact statements are generally prepared statements detailing physical, psychological, financial, and social harms that the victim suffered as a result of a crime. Um, Essentially, these statements can be delivered in person by the victim, or it can be delivered to the district attorney to read. But essentially, victims have the right to have their voice heard. Now, victims aren't always happy with sentencing decisions. They may not always feel like they got justice, but victim impact statements at least bring them into the process as a um, cooperator and lets their voice be heard. There's an important case that you need to be familiar with in terms of victim impact statements, and that is Payne versus Tennessee. So remember, victim impact statements were introduced in the 1970s, and there was some controversy with victim impact statements. Uh, and it wasn't until Payne v. Texas that the U.S. Supreme Court weighed in on victim impact statements. So essentially, in 1987, Purvis Payne took cocaine, drank some malt liquor, and was watching porn. And after he was done doing all that, he attempted to rape and murder an acquaintance of his and her 2-year-old daughter. Um, the victim had 42 stab wounds, and there were multiple stab wounds to her daughter. Payne was convicted due to evidence, but appealed his conviction, stating that the victim impact statement that was given at sentencing emotionally influenced the jury to recommend the death penalty. And so he stated that basically his Eighth Amendment right was violated by victim impact statements being given. Um, the Tennessee Supreme Court upheld his conviction and basically said no, victims have the right to have their voices heard. It had nothing, it did not impact their view of your guiltiness. And so they upheld the conviction. Well, Payne appealed that decision to the U.S. Supreme Court. And remember, the U.S. Supreme Court is the highest court in the land. And essentially, the U.S. Supreme Court upheld that victim impact statements were not unconstitutional and did not violate the Eighth Amendment. And so after 1987, you started to see victim impact statements, the use of them considerably increase because now we, as a system, recognize the importance of these not only for the victim, but also um, kind of noted that they had some legal standing to them and some they were backed up by the Supreme Court in their validity. Now, remember last week when we talked about victim impact statements, there were some benefits that was highlighted by a judge, and essentially, that is how victims um, participate in this system is through giving these type of statements and kind of letting the community and the court know they're suffering. I'm not going to spend a lot of time on restitution. Um, I would say um, we've talked about restitution. It was first used in 17th century English courts. It's essentially meant to repair stolen or monetary property. Um, Restitution operates in both the criminal and the civil justice systems. And we typically see restitution court ordered at the sentencing hearing. So, once a offender is um, sentenced, they serve time in jail or prison, depending on the length of the sentence. Victims have rights, and so while the offender is incarcerated. So when the offender is up for parole hearings, the victim is notified of this. And essentially, parole hearing are hearings that determine whether an inmate should be released from prison to the parole supervision in the community. There has to be specific criteria met. Normally, they have to have completed a certain length of their sentencing. but victims have the right to attend those hearings and to speak at those hearings. So they get to continue giving victim impact statements even at these type of hearings. Their appearance can be one of three ways. Please take notice of that. They can make a video statement and send it to the parole board. They could submit a written or recorded statement, or they could be there in person and give an oral statement. Um, Results of those parole hearings are provided to the victim, and every time an offender comes up for parole, the victim um, is notified of that and is able to have these rights to be present at that hearing or through these three appearance means. If an offender escapes while incarcerated, um, the victim also has the right to be notified of that through the VIS, which you learned about week 3 or 4, I believe. Um, but essentially, you will see that a big portion of victim rights is the right to notification and just kind of know what's going on, not only through the trial, but through the offender's incarceration and kind of keeping tabs on that offender, knowing what's going on, just to make sure that if the offender gets released and they feel like they're in danger or something like that, they can better prepare for that. All right, so let's talk about the civil system. That was the criminal system, which we're all pretty familiar with. Now, remember the difference in the criminal system and the civil system is really the role of the victim, just like it is between the retributive justice model and the restorative justice model. How we treat the victim and the view of the victim are completely different in the system. So let's talk a little bit about the civil system. So the civil system is a system of private justice that governs transactions and grievances among individual parties. Um, Parties are private individuals or corporations, and the language is different between the civil and criminal. So in the criminal system, you have a crime, you have offender, you have victim, things like that. In the civil system, you have parties, you have torts. I think we'll get to it here in a minute, but just in case we don't, um, the crime in the civil system is referred to as a tort. Um, Here is one big difference that you should probably be aware of, and that is it is the plaintiff's burden of proof to prove the elements of the claim against the defendant. So the burden of proof is on the quote unquote victim or victim's family to prove um, the elements of the claim. It's also important to note that in the civil system, it is the responsibility of the victim to bring suit against the offender. So in our criminal system, really law enforcement and like the district attorney's office will decide to bring charges. In the civil world, it is individuals. So it is the victim who would be considered a party. Um, it is their responsibility to file the civil paperwork to bring that to a civil court. So I talked about this a little bit earlier, but the crime, quote unquote, is referred to as a tort in civil procedure. And so really like it's a language thing. And remember, civil procedures, um, your relief is monetary normally. Here's just a quick rundown kind of flow chart of the civil world. You can kind of look at this yourself. But there are some major differences between criminal and civil, a lot of it being language, and the biggest being kind of the victim's role in those systems. So, some considerations for pursuing civil justice. The control is completely in the victim's hands. Payment can be awarded for restitution, and recovery of that award is not always straightforward, though. So, you may have seen on the news that E. Jean Carroll and Donald Trump have been in a civil proceeding, and she just got like $85 million and so awarded to her in relief for defamation. So it's really like Trump plans to appeal that decision, but in New York, they have to hold a bond. And so he has to put money into a bond um, and while all of this system plays out. So, if someone is awarded monetary damages, um, they might garnish wages, they might um, uh, look at assets and make people sell assets to get the money for the restitution, things like that. Um, Another huge thing in the civil justice world is that the victim's history and medical treatment are open to scrutiny. There has been a lot of protection added to victims in the criminal world about what's admissible in the trial, what's not admissible, especially in terms of rape victims and previous history. All of that kind of goes out the window in civil courts. They operate under different evidentiary standards. And so you see that the history and treatment history and things like that are all open to be kind of litigated. And then there are statute of limitations, just like there is in criminal, but there are also statute of limitations for civil matters. There's time limits that are typically between 1 to 3 years, um, but there are also longer limitation limits with respect to obtaining compensation, so like up to 20 years, things like that. All right, we've gone through a lot of information. Make sure you finish reading this week, and kind of as you're reading, look at how the victim goes through this system. There's a lot of steps. Last week we kind of talked about the victim witness program, and remember, really that program is there to help guide the victim through these steps and through these processes of the criminal side and things like that. As always, if you need anything, feel free to reach out. Um, I would remind you that you have um, an activity that is due relatively soon, along with another activity that is opening. So make sure you stay on those activities. Otherwise, I will talk to you all later. Thanks.